Good afternoon and good morning. Welcome back to the virtual VETS'20 webinar series. Today is part 12 of our 17-part webinar series hosted by the National Veteran Small Business Coalition. I'm Earl Morgan, the NVSBC Program Director, and to our new attendees, thank you for joining us today. Again, thank you to our 8 sponsors who made this webinar series possible. So we've added 12 new topics to our webinar series. If you purchase the entire series for this webinar, you'll be automatically registered. If you have not purchased the webinar series and would like to attend any of the additional webinars, please visit the NVSBC website, VETS'20 registration page for details. Today's webinar is 1 hour. It's being recorded. If you have any questions, please type it in the text box on the screen. We will try to answer all of the questions on this webinar. And if by chance we miss your question or do not have the time to answer it, we'll get the answer to you and post it on the Virtual Vets Replay webpage. Now let me introduce our moderator, the Executive Director of the National Veteran Small Business Coalition, Mr. Scott Jensen.
Thank you, Earl, and good afternoon, good morning to everyone out there. Again, we thank you all for joining us. We've got another great installment in our series today, and we're excited about it. I want to introduce you to someone who's not only a friend of NVSBC's and a dedicated supporter of business owners, but was also very early on instrumental in getting this webinar series off the ground, and we sure appreciate he and his firm's support and involvement. But I do want to introduce you today to Josh Duvall. Josh is an attorney and a managing partner at Mattross Edwards LLC, a government contracts business and cybersecurity law firm with offices in Washington, D.C. and Florida. Josh counsels and represents government contractors in a broad range of procurement and business issues, everything from bids and claims to teaming and joint venture agreements, small business administration matters, employment and compliance issues, just to name a few. Josh focuses his practice on helping small and mid-sized civilian and defense contractors, including those in the IT, healthcare, cyber, training, and professional services space. Josh is vice president of the bid protest and membership committees for the ABA section of the public contract law, is a certified information system security professional, and is a frequent presenter and author on government contracts and cybersecurity issues. Josh, it's so great to have you here today. Again, thank you for your support to this series and your support to our members and everyone else who's present here today. And it's a pleasure to have you with us. I'll turn the floor over to you, and we look forward to spending an hour with you here. Thanks.
Thanks for the introduction, Scott, and welcome to everyone that is attending today. This has been quite a unique summer for, I think, all of us, and it truly is an honor to be participating with the NVSBC on a number of things, including today's presentation, which is aptly named Basic Training, Small Business Legal and Regulatory Issues. Next slide, please. And I thought about, this topic was sort of born out of, let's call it Zoom fatigue. I know we've all been doing a lot of Zoom meetings and webinars. And so part of my thinking here today was to, be rapid fire, cover a lot of topics to hopefully keep everyone sort of at least awake and, attentive, but to cover these things at a high level. As Scott mentioned, I'm the founder and managing partner of Mattross Edwards. For those of you who don't know, Mattross is a military rank of the American Revolutionary War. It was ranked directly below a gunner, so they were, cleaning and firing and sponging the guns. The cannons are on the front line, so that's where our name's derived. My contact information is there on that screen, and if you'd like to check out my blog, it's govconjudicata.com, and there's my LinkedIn profile. Next slide, please. Briefly, this is what my firm handles. I don't want to go into that, but that's there. I think Scott mentioned it earlier. Next slide. I'm trying to be mindful of everyone's time here. And a quick important disclaimer for everyone. What I'm going to be talking about today is for generalized informational purposes only. There's a lot of nuance to some of the SDVOSB regulations and the small business regulations that are not going to be discussed in detail today. And so the webinar isn't really intended to provide anyone with legal advice, but really is sort of designed to plant a few seeds in your brain so that, you know, when these issues do come up, a flag should go up and say, oh, wait, I remember hearing that on a webinar. And of course, there are a number of other recordings that the NVSBC has posted online. And so I also urge you to check those out as well. Next slide, please. And so what are we going to be talking about today? Well, 4 principal areas: agreements, debriefings, bid protests, and cybersecurity. These are the things that small businesses and SDVOSBs will typically need to have some familiarity with. Obviously, for folks who are priming and going after larger awards, some of the protest issues and debriefings are a little bit more important. But broadly, all of these issues are something that, at least at a high level, folks should be aware with as you're entering into or trying to succeed in the government marketplace. Next slide, please. And so when we're talking about agreements, next slide, I'm focusing principally on 3: operating agreements, teaming agreements, and joint venture agreements. And these are sort of foundational that folks will come across. At least the first 2 are paramount importance, particularly if you're a subcontractor and you're sort of entering into these teaming agreements. But at the baseline, one of the things that folks need to worry about are the operating agreements. So we can go to the next slide. And so the operating agreement is typically sets the foundation of the company. Most states have their own Limited Liability Company Act, and I'm going to talk about LLCs for the bulk of the conversation, because most companies that I've come across have organized as a LLC, although it could be a partnership or a corporation. But the operating agreement is something that you'll set out the membership rights, voting rights, tons of provisions. When you're starting out as a government contractor and you're a solo owner, a lot of folks will tend to just use one that's online, and that may or may not be okay. But when you start getting into a situation where there's more than one owner or member of the LLC, is what I mean when I say owner, then issues start to crop up. And SBA has some strict regulations, if we can go to the next slide, that sort of cover these operating agreements. And these are important because although a normal business attorney can draft an operating agreement where you can go on one of the online agreement websites and download operating agreements for your state, whether it's Maryland or Virginia or DC, there's still issues with respect to ownership and control that sort of pop up in operating agreements that folks need to be aware of. And at a basic level, the rules are designed to protect the SDVOSB. So I'm focusing on service-disabled veteran-owned small businesses for this example, because that is a socioeconomic category in the Title 13 regulations. And so we see here that the concern must be unconditionally and directly owned by one or more service-disabled veterans. And one thing that has tripped folks up before, and it's worth mentioning, is the LLC regulation states that it's got to be 51% of each class of membership interest. So when we talk about classes of membership interest, you may have Class A and Class B members, and they might have different rights with respect to what those interests entail. But the regulation says that they've got to have 51% of each class. So if you're in a situation where you want to take a trusted business executive and make them a member of the company as a means of rewarding their contributions to the company, and you only make them a Class B member, this is something to be aware of, because down the line, as your company continues to grow and goes after larger and larger awards, that's when some of these protest issues come up. And although a bid protest is a separate thing, What I'm talking about with respect to these specific rules are SBA size or socioeconomic protests, and that's where a company challenges the concern's ability to even be awarded a contract. And so with respect to multi-member LLCs, this is something that folks need to be aware of. There was a recent case, I believe, out of the Federal Circuit where a company was deemed ineligible as an SDVOSB because the owner was giving ownership to his family members. And so while that's not typically viewed as an adversarial process where where you're thinking like, I need to have an attorney, I'm just helping my family out, and I want to make my family members members of the company so that when I pass on or do other things, that it stays in the family, you still have to conform with the Title 13 regs, and that's something that folks might overlook unintentionally just because they're not really dealing with a quote outsider, which is just someone who isn't part of the family. So if we can go to the next slide, the other side of the operating agreement that can be troublesome are the control issues, and those are under 125.13. And these are important for a number of issues, but when we're talking about control, the service disabled veteran or the SDV or more than one SDVs have to manage and control the day-to-day business operations and long-term decisions of the company. And the rules under .13 are pretty extensive. If we look at it, there's the general rule is 125.13a, managerial position and experience is B, control over the limited liability company is D, and so that is the service disabled veteran must serve as the managing members with control over all decisions of the company. Then there's the corporation. If we continue to scroll down, we have critical financing, business hours, close proximity. So, and this is a very interesting one, and especially with respect to a lot of startup companies that may not have office space. The rule says that there's a rebuttable presumption that a service disabled veteran does not control the firm if the individual is not located within a reasonable commute to the firm's headquarters. So there's a lot of things that folks need to be worried about when it comes to control issues. The other side of the coin, in terms of controlling the day-to-day operations of the company, are the extraordinary circumstances, which is a specific carve-out for SDVOSBs. Now, why is this important? Well, there's a number of SBA OHA decisions, which are SBA Office of Hearings and Appeals, that will talk about 8A or woman-owned small business or the hub zone small business, and you can find their decisions online. But a recent change from, I believe, October of 2018 was the codification of 5 extraordinary circumstances where a minority shareholder can exert some sort of control, because these are the situations that are not concerned with the quote day-to-day business operations. Now, here we have 5 things: adding a new equity stakeholder, dissolution, sale, merger, or declaring bankruptcy. A troublesome area is where your company is an SDVOSB, but you're also a hub zone or an 8A company. And remembering that if you're going to be competing under a SDVOSB set aside, that these 5 extraordinary circumstances are going to be the limitation on which you can exert some sort of negative control. Other SBA decisions have said that negative control is okay if it's changing the charter of a company, issuing additional stock, confession of a judgment is another one, changing the character of the company's business. So all these other extraordinary circumstances where a minority shareholder has an ability to, by vote, exercise some control over the concern. With respect to SDVOSBs, we're really limited to 5. And so that's something to be aware about, especially if you're a company that has multiple socioeconomic designations. Next slide. And so now that we've talked about some of the operating agreement issues, what are the teaming agreement type of issues that come up. And this is pulled from the FAR, and this is FAR 9.601. And the contractor team arrangements is typically, you'll see them in terms of prime and sub relationships, and then also the joint venture relationship. Next slide, please. And so when we're talking about prime sub relationships, we're talking about one company acting as the prime contractor who is in privity of contract with the government, and then a subcontractor who is not in privity but nonetheless part of the team. So folks typically form these teams to enhance their capabilities. Maybe the subcontractor has 3 or 4 folks that are subject matter experts or SMEs that are necessary to compete at a high level for procurement. You may think about forming a teaming agreement with a prime to go after a contract. The difficulty here is, although the agreement might set out exclusivity provisions or work share proposal activities or responsibilities of the parties or setting out limitations of liability or confidential information, a lot of times folks have an issue where the team sort of breaks down. And the question is the agreement enforceable, to make the prime contractor enforce a subcontract with the subcontractor if there's sort of a breakdown? And that typically, the answer is usually no. There are some circumstances where you can try to mitigate that issue, but as we've seen time and time again, especially in Virginia, and I'm sure other jurisdictions, it typically these agreements are viewed as an agreement to agree to some sort of future subcontract, and courts just won't enforce that because there really isn't a meeting of the minds at the time of contracting. And so that's something to be aware of. There are instances where you might have a subcontract ready to roll, and the contingent precedent to the subcontract being valid is the award of a contract. That there's one case that seems to sort of hint that is acceptable, but by and large, these agreements are typically viewed as just mere agreements to agree. So it's when I talk to clients about going into this avenue, it's really necessary to sort of set expectations that it's possible that if there's some sort of breakdown, that especially if you're the subcontractor, that the prime may sort of leave you at the altar, so to speak. Next slide, please. I guess one thing before I hop into joint ventures, the other thing to think about, which I didn't make a slide on, with respect to the prime sub relationship, are some of the affiliation issues with respect to the ostensible subcontractor rule. And that's a situation where the subcontractor is really performing the primary and vital requirements of the contract, and the SBA will say, well, you're not really a subcontractor, you're the ostensible subcontractor, and they'll cause the two companies to be affiliated, which may or may not render your company eligible for award. But turning to joint ventures, it's the same sort of situation, except now we're in a situation where the joint venture is the prime. It's no longer a prime and a sub. The joint venture is the prime. But SBA has a couple of interesting rules that have tripped up folks. One is the 3 and 2 rule, which is for purposes of joint ventures, they're really supposed to be limited in duration. There's talk that SBA is going to change this, but for now, we're limited to 3 contracts in a 2-year period, which is why if some of you see in sam.gov, you'll see JV1 or JV2 or JV3, it's because they have utilized the earlier JV to the extent permitted under Title 13. And so one thing to remember with respect to joint ventures is SBA, again, has strict requirements that these organizations need to follow. And if we go to the next slide, and what that means is if you're not following these, the regulatory regime to a T, it can render your company ineligible for award. And so where can folks, the most common things that folks will be doing to set up a joint venture is where they're both small business and they want to compete as a small. And the other side of the coin is we have an SBA approved mentor protege agreement in place. You'll be able to form a joint venture. So typically joint ventures are affiliated by definition, but these are the exceptions. And so if you're in a situation where you're deciding to form a joint venture, there's I think 12 items that SBA looks for. And if you look at SBA's sheet, they have it, it's a little bit more exhaustive than that. But under 125.18, we have exhaustive list of what the joint venture agreement is required to include for it to be considered eligible for award. And that is the managing venture or the small business must own 51% of the joint venture. Profits are commensurate with the work. And one item that seems to trip up, or two items that really trip up a lot of small businesses, are the third and fourth points here, which is itemizing all major equipment, facilities, and other resources. And then the other side is responsibilities regarding contract negotiation, source of labor, and contract performance. Now, if you're in a situation where you form a joint venture and then months down the road you go after a new contract, you still have to go back and itemize the major equipment, facilities, and other resources that are pertinent to that contract. And likewise, the responsibilities regarding contract negotiation, source of labor, and contract performance. This has come up on a number of occasions. You can read those decisions at SBA's, the Office of Hearings and Appeals website, and they basically are following the regulatory regime to a T. And where these provisions are absent from the agreement, that's found to be non-conforming with the regulations, and therefore the company will be deemed ineligible. So that's something to be mindful of when you're forming joint ventures. This, again, is something that sort of crops up on a number of different OHA opinions. The other side of the coin here is there's a recent case out of OHA that sort of confirmed SBA's thinking with respect to joint ventures, to the extent that they rely on the control aspect of the earlier regulation I was talking about under 125.13. And that is, if you have a joint venture where the minority venture has some say in the day-to-day operations of the joint venture, at least as early as I think May, SBA has sort of borrowed the logic of, even though it's not in 125.18 with respect to joint ventures, they're still saying that the managing venture has to manage and control the day-to-day operations of the company. So that's something to be wary about when you're forming your JV agreements. Are those the other 5 extraordinary circumstances? Now, I haven't seen a case that has brought those into the JV context, but again, those 5 items were, I believe, in October of 2018, so it's still relatively new, but it wouldn't surprise me if we see a decision that comes out that sort of confirms that notion, given the type of decisions we've seen coming out of the OHA on with respect to ownership and control of a concern. And so with that sort of wrapping up out of the way here, when we're talking about agreements, the 3 that come to mind here for small businesses and SDVOSBs are the operating agreement. Again, we have ownership and control issues. The teaming agreement, which is in many instances viewed as just an agreement to an agree, so it's hard to enforce it. A court will not enforce it because there isn't. What they'll say is there's no meeting of the minds. There was a recent decision out of Fairfax that sort of confirmed as much earlier this summer. And finally, the joint venture agreements, which again, as I mentioned, are governed by a particular regulation that folks need to be wary of, and also paying attention, of course, to SBA OHA decisions. And so now let's next turn to the next sort of phase here, which is debriefings. Next slide, or 2 slides up. And when we're talking about debriefings, we're sort of entering in a different phase of government contracting. Now you've had an opportunity to compete for an award, and what is this aspect of government contracting? Well, it's really about transparency in procurement, and it's also a way for folks to learn a little bit about why you weren't selected. And these debriefings are available under FAR Part 15 procurements and task and delivery orders that exceed $5.5 million under FAR Subpart 16505B6. And so if you've won an award, you have the opportunity to request a debriefing, which I recommend. And if you're the unsuccessful offeror on the other side of the coin, I highly recommend requesting a debriefing. Next slide. And so what do we have? We have the pre-award debrief and the post-award debrief. One thing I'll mention about this 3 days of award notice, the GAO has a decision that has clarified what that means. And basically, unless otherwise indicated on an agency's website, the third day ends at 4:30 p.m. local time is when an agency close of business happens. So if you receive a debriefing, unsuccessful offeror letter on Friday, Saturday, Sunday, Monday comes around. If you miss that 4:30 cutoff, or unless it's stated elsewhere on the website, it will be treated as filed the next business day, which is on day 4. That has an interesting implication with respect to protests. So while you may still receive a debriefing, it isn't, quote, required under the statute. You can go to the next slide. So be sure that you request your debriefing, include that it is timely, specifically ask for a debriefing under the FAR Part 15. One important note is to take the first date offered. Again, I mentioned that awardees and unsuccessful offers should take this opportunity. And again, debriefings impact the protest shot clock. So now that we've sort of talked about some of the high-level issues, I will say that there's a debriefing and bid protest tip sheet that I put on my firm's website and my blog. It wasn't too long ago that I published that. It's a one-pager that sort of covers this issue. I did not include it in the slide deck, but if you want to go to that, just check out the blog and you'll see it. But what are we going to be learning during the briefing? And it's important to sort of take this in stride. So if we go to the next slide, we have a pre-award debriefing, which is basically an issue where you've been removed from competitive range. And what are you going to be learning? Well, here are the minimum requirements. As you can see, there's only 3 items. I will make a point to note that under the pre-award debriefing, do not delay. The agency may ask you if you want a pre-award or a post-award debriefing. Always request the pre-award debriefing if you've been removed from competitive range. It can impact your ability to protest later on. If the agency in its own accord decides to postpone a pre-award debriefing until after the award, let them do that on our own accord, but don't do that on yours, because it, as I mentioned, has an implication for protests. But as you can see right now, there's 3 things: the significant elements in your proposal, the summary of the rationale, and reasonable responses to relevant questions. So there's not much going on. Again, these are minimum requirements. Unfortunately, what we've seen with pre-award and post-award debriefing is that the agency is treating these minimum requirements as just what they're going to provide, which causes some sort of trouble for small businesses, because they sometimes just want to know why it is that they lost the award so they can better prepare for the next go around. We can go to the next slide. What is not going to be discussed in a pre-award debriefing? Again, this is removal from competitive range, the number of offers, the identity, the content of their proposals, the ranking. So these are things you're not going to get. When we turn to the next slide, we see the minimum requirements for the post-award debriefing. And it's a little bit more robust. We have the government's evaluation of significant weaknesses or deficiencies, and that is a significant weakness and deficiency is defined in 15001. The overall evaluated cost or price, an overall ranking if developed, which can be helpful in determining whether or not you will be able to show prejudice. If you're 5th or 6th in line, you may have a difficult time achieving any success with a protest before the Government Accountability Office, because there are folks that are ahead of you in terms of whether your price trade-off or technical evaluation, where that put you in terms of your competitors. Importantly, here we have the summary of the rationale for the award, and again, lastly, reasonable responses to relevant questions. That can be sort of an enigma. Sometimes your answers will be simply, we followed law and regulation and the requirements set forth in section L&M and the solicitation. And so now you're thinking, well, that didn't really answer my question. If we can hop to the next slide, here are the items that won't be discussed. You're not going to get a point-by-point comparison or learn any of the trade secrets or privileged or confidential information. And so when we take these items together and we have, let's just focus on the post-award debriefing, we have an understanding of what is going to be required and what is not going to be provided during the briefing, we can go to the next slide and formulate a debriefing approach. And why do I talk about a debriefing approach in terms of a process is because a lot of the times that I've talked to contractors, they approach the debriefing as a passive exercise where they're waiting to learn information. And what I like to do is to help folks realize that this is an important aspect of government procurement. You have an opportunity to collect information, so we have information gathering, but also on the other side of the coin is relationship building. So if you're the unsuccessful offeror, there's a couple things that you want to get out of the debriefing, which is how do I improve? How do I put myself in a better position for the next go around? But also, how do I attack the debriefing in a manner that leaves the agency personnel with a positive view of our company, right? And so how do we take all that and put ourselves in a position to sort of attack the debriefing in a manner that will enable the company to benefit? And one thing is to understand what you know, with the speed of government acquisition, there could be quite a gap in between proposal submission and notice of unsuccessful offeror. So now is the time to come back with fresh eyes and review your proposal and then review the solicitation and see what was required and what they were looking for versus what you actually proposed. And use that in conjunction with the items that I just mentioned, the minimum requirements, to formulate questions in advance that you would like to have answered, and send them off to the agency, and hopefully they'll provide you with a little bit more robust opportunity. Understand what you won't know, you're not going to be disclosed, and utilize the opportunity to sort of get as much information as you can. There are folks out there that, depending on the size of the procurement, they sort of know going in, hey, look, this is a strategically significant procurement. We've got to win. We're investing a lot of money in bid and proposal. We've hired outside consultants. We've got to win this award, or we've got to get on this vehicle. They know sort of going into it, hey, I'm going to win. If I lose, I'm protesting because it's just that important. And there's the other side of the coin where, something is learned during the debriefing and you're like, well, wait, this doesn't seem right. And so you're using the opportunity here to sort of set the foundation, have a good rapport with the agency, but to really just collect the information. Maybe there's a procurement that's coming down the pipeline that they think that you might be a better fit for. You don't want to head to the debriefing hot-headed and sort of destroy that potential opportunity. When you're attending the debriefing, if the agencies have wide latitude here with debriefings, it could be a Zoom call, phone, in person. They might send you a letter. Be wary of the debriefing that shows up with your unsuccessful offeror letter. They may choose to do that. And so that you got to be reminded of the timelines that we're working with here. And if it's one of these debriefings that is in person or on the phone, have someone take notes. And then when you're done, you're not using this opportunity to challenge the agency's evaluation methodology or their source selection decisions. Come back to your office for the third phase, right, and regroup with your leadership team and decide whether or not you're going to advance with a protest or figure out what you could do better to position yourself for the next go around in terms of whatever your strength is in government procurement. And so with that out of the way, let's turn to the next slide, or the next two slides. We're going up into the bid protest realm now. And so we've sort of segued from learning some information about the conduct of the procurement, and now we're sort of trying to figure out if we're the unsuccessful offeror, should we file a protest? Well, we have three procuring fora that sort of will hear a protest. We have agencies. There's also the FAA, Office of Dispute Resolution for Acquisition. They do not follow the FAR. The FAA has their own practice, so we're going to shelve that for this point. But we have the agency level protest, and we have the Court of Federal Claims protest, which is where the Department of Justice attorneys in the National Court section will litigate that on behalf of the government in conjunction with agency attorneys. And then you have the GAO bid protest forum, where you're dealing with agency attorneys, and that's where a lion's share of these protests end up. Next slide. When we're talking about protests, we're talking about really two principal types. We have the pre-award ambiguous solicitation language, efforts that improperly restrict competition, using an unreasonable evaluation methodology. I think there was a recent protest that, where the agency basically said it had to be Amazon or Oracle or Amazon, Google, or Microsoft, and Oracle, I think, was the challenger, and sought to challenge that as unreasonably restricting the competition there, and sort of brand name type of protest. And the other side here is the post-award protest, where you've sort of coming out of a debriefing and you're wondering whether or not the agency's evaluation was reasonable. Was the selection decision reasonable? Were there issues with cost or price? I will say that just sort of going back one moment, there's a lot of resources online that folks can sort of search on Google with respect to potential questions to ask for a debriefing. There's a lot of websites out there that have information. And so depending on the type of procurement and the solution that you offered and what information you learned during the debriefing, that's something to be aware of. When we're talking about protests, let's scroll down to the next slide. We're talking really about interested parties having the opportunity. So that's the actual or prospective bidder or offeror who has a direct economic interest that would be affected by the award or the failure to award a contract. And the other side of the coin here is interveners. While they're not the active participant in the protest process, if you're the awardee, you have a right to intervene. You can do that at GAO, you can do that at the Court of Federal Claims. You're really doing it for a couple of reasons. One is to protect your win. There are arguments that the agency may or may not make, and that you may want to make. You might be able to help with seeking dismissal. Folks intervene to protect their confidential information. You're in the better position to know what's proprietary to your company than the government would be. And also, some interveners will use it as an opportunity to, if they can't persuade the agency to avoid taking corrective action, we have seen interveners take the approach of trying to shape the corrective action in a manner that is not only consistent with law and regulation, but also with their best interests. So that's another thing to be thinking about. When we're thinking about protesting, going to the next slide, one thing to remember here are timeliness issues. So we have strict filing deadlines at GAO. We have the deadline is at 5:30 p.m. GAO has implemented electronic filing, and so you have basically until the clock strikes 5:31 to pay your fee and to have your protest be filed timely. One thing to remember about is, in the heat of the moment, you're a small business or a SDVOSB, and you know your competition. Chances are you know who the key players are in your field. You know who's succeeding and who's not succeeding. So all these will be used in your formulation of whether or not you want to challenge an award. There's the other side of the coin that I mentioned earlier on with respect to operating agreements, which would give rise to a status protest, or the size protest, which is a separate issue from bid protests. They're at with SBA, and sometimes you'll have simultaneous tracks. So while GAO won't hear a protest challenging something that impacts SBA size regulations, sometimes you'll see them. In many cases, it's because they missed the deadline to file, but also there's an exception where the proposal on its face basically says that you're not going to be complying with the SBA regs. But something to think about when you're in the unfortunate position of being the unsuccessful offeror is that sometimes there's a parallel track here. With the next slide, with respect to solicitation defects, you have to file your protest before the time for receipt of proposals. And so basically you're in a situation where you can't bid on a procurement, lose the procurement, and then try to come back and challenge the solicitation was erroneous in some manner. Right now, that you hear that in the blue and gold case in the Court of Federal Claims or the Federal Circuit decision that basically says you can't just sit on your rights and then hope for a second bite there. So with respect to for the next slide, if you're dealing with something that's not a solicitation defect, removal of competitive range, or you've received the notice of unsuccessful offer or letters, you have 10 days when you knew or should have known the basis of the protest. Interestingly, there was a case, I think last year, where the protest ground was learned during a phone call, which was subsequently confirmed in writing. And so if you do receive a phone call from the agency explaining anything for why you lost before any type of written documentation comes in, be wary that that could be the triggering moment for the shot clock here. When a debriefing is requested and required, there's the exception to the timeliness rule. So we can go to the next slide here. And that basically says the initial protest shall not be filed before the debriefing date offered, right? This comes into play when the debriefing is required. The debriefing exception does not apply where, for example, you requested a debriefing on the 4th day or the 5th day, and the agency voluntarily decides to give you a debriefing. That debriefing is not required because you didn't timely file it. And so that's something to be aware of in terms of the days that you need to be thinking of when the shot clock is triggered. But even though we have 10 days to file a protest, there's a couple other nuances here that are worth mentioning. Next slide is the seek a stay, which is automatically triggered. So if you're filing at the Government Accountability Office, you want the performance to stop. And that is automatically triggered if you file your protest the later of 10 days of award or 5 days after a required debriefing. And I underline required to remind folks that it's got to be timely filed for it to be required. There's another sort of exception here, the enhanced debriefings, if you're dealing with, for the next slide, for the Department of Defense. They've included in Title 10 an opportunity for a disappointed offer to submit within 2 business days additional questions. So if you submit your additional questions, the agency has 5 days to respond, and then the debriefing is considered closed when you receive a response. There's a case on appeal right now where the company decided to not ask additional questions, and the question in that case is, what day was the debriefing closed? Was it when they had the debriefing, or the debriefing include this 2-day window to ask questions? So that could be an issue that gets decided sometime in the next several months here, but in the meantime, pay attention to, if you're conducting business with the Department of Defense, the language in your letter that you receive that describes the enhanced debriefing procedures. So we can go to the next slide here. So now that we've talked about that, what are we not going to hear at GAO? Well, they're not going to listen to a contract administration issue. Again, SBA issues, protests that are untimely, protests that lack a detailed statement of the legal and factual grounds, and then protests from subcontractors. And so if we hop to the next slide, we can get an idea of where the lay of the land is in terms of protest statistics. And the items that are worth paying attention to here are sustain rate, which has hovered around 13, 15, and 17% of the last couple of years. But the item below that is the effectiveness rate, and that takes into consideration corrective action, which brings it to about 40. I can't read that, but it looks like 44%. And so, when you're filing a protest and you engage counsel, this takes into consideration all the protests that were filed. You have an opportunity to maybe persuade corrective action. The question is, will that ultimately result in you winning the contract at the end of the day? It's too hard to say in a webinar of this whether that is achievable. It has been done before, but the likelihood of that is a little bit lower. But something to bear in mind when we're talking about successful protest grounds. What are the grounds that lead to that? If we go to the next slide, how do we persuade the corrective action or have GAO sustain? We're really focusing on procedural flaws rather than subjective differences with the agency's evaluation. So when we think about protests, we have the opportunity to prepare for the debriefing as one layer of setting expectations, but also I I didn't win could be your reason, but we need to dig deeper. And so was there an underlying flaw in the procedure, which is what GAO is typically looking for? And that could be an unreasonable cost of price evaluation. Say you learned during the debriefing that the agency didn't perform price realism analysis, but you think one was required under the solicitation, then maybe that's worth challenging. Past performance evaluation, you know, those typically surround scope and complexity issues. You know, your offer, the awardee's past performance doesn't measure up to the type of complexity that's required in the current solicitation. Was the evaluation reasonable? Technical evaluation, unequal treatment, where you're in a situation where you're seemingly being treated differently than the awardee, or an inadequate documentation of the record. We've seen that come up, and that's a situation where the agency doesn't fully explain the rationale. And so now that we've sort of talked about the protest issue, let's segue, and I've got about 12 minutes left. I'm going to try to zoom through this. We're going to change gears again and hit cybersecurity. And so we can switch 2 slides. As mentioned earlier in the webinar, my certified information system security professional, CISSP. I work for government contractors in the DC area, malware analyst, doing systems and email administration, IT help desk support of that nature. And so it's something that I've been around for a while. But when we're talking about government contracting or even just business in general, I think there are important cybersecurity light bulbs that should be going off. Right now, we're dealing with a regime in the DoD procurement space that's going to be changing. Right now, we have DFARS 252-204-7012, which requires contractors to provide adequate security on covered contractor information systems by implementing the 110 controls under NIST Special Publication 800-171. Now, as it currently stands, contractors are self-attesting to that, and they're allowed to have basically a POAM in place, which is a plan of action and milestones. So if you have a situation where you've got 90 of the controls in place, and you've got a plan of action to achieve the remaining 20, you would be in compliance with the current lay of the land. You also have the FAR clause, which is the safeguarding information clause 52-204-21. And then the thing that is sort of buzzing around DoD procurement now is the cybersecurity maturity model certification. Is this 5 maturity level. Level 1 is the most basic. It sort of coincides and follows the 52-204-21. All the way up to level 5, which is beyond NIST Special Publication 800-171. In fact, level 3 under the new model has 20 more controls than NIST Special Publication 800-171. There's talk that DoD might remove the extra 20. Not really quite sure if that's true or not. I've seen some things online and recent commentary that makes me think that they might be at least thinking about it, to make level 3 harmonious with Special Publication 800-171. But this is important for all contractors, large and small, primes and subs. It will essentially be a go, no-go criteria. And so folks who are wanting to do business with the DoD need to be aware of that. The other important point, it's also part of the DFARS clause, is with data breaches. We're seeing a lot more news articles of advanced persistent threats, nation state hackers targeting the defense industrial base. And so one of the things that is required and folks should be thinking about is having an incident response plan in place. How are you going to respond if you're in the unfortunate situation where you show up to work one day and your computers are locked out and there's a red skull and crossbones saying, we've encrypted your computers, and if you don't pay us 10,000 in Bitcoin, we're going to delete your files. If that gives rise, that's what you're seeing when you walk in the office. Now you're thinking, I've got to implement my incident response plan, which also should discuss your notification requirements. And under the DFARS rule, you have 72 hours to report. So that's something to be aware of. The next sort of item that's worth noting with respect to cybersecurity is the insurance side. Now, if we go to the next page, There are different options for cyber insurance. You have cyber liability, you have property policies, you have errors and omissions policies. But even within the policies that sort of talk about cybersecurity and privacy, there are a lot of variations in between these policies. It's even though insurance companies have been, you have AIG and Beasley and Chubb and Travelers and all these insurance companies selling insurance, it's still they're still developing their the language that's used in these policies. They can be very dense documents, but typically you'll buy cyber coverage to help with repairing computer systems, and some policies might not include that, and that may be a property policy you'll need. Data forensics. So if you've received that skull and crossbones and you have the cyber coverage that covers data forensics, then typically you'll have a pre-vetted third party that has worked with the insurance company before, will come in and see where the indicators of compromise are, where they think the malware originated from. There's a lot of statistics that they have, and they know the likelihood of payout sometimes, if whether or not the hackers are going to truly unlock your data if you fall victim to an attack, and also the law firms and ransomware. And so one thing that it does is pay for all these things, but as I mentioned, there's a lot of variety in between coverage options for cyber insurance. And one thing that sort of has come and gone here are the exclusions. Now, this is sort of a really difficult subject because attribution of cyber attacks can be challenging. Right now, that's being litigated in a court, I believe, in New Jersey, which was, the attribution of a Russian attack that caused, I believe it was the NotPetya virus, and whether or not that constituted an act of war, thereby excluding coverage under the policy. The other thing that sort of is a head scratcher, but is sometimes excluded, are social engineering attacks. So if you fall victim to a phishing scam where someone's sending malicious emails and one of your employees accidentally clicks it, that may or may not be in your policy depending on how it's written. Now, again, these policies can be 30 to 50 pages, and the exclusions can be interestingly worded, to say the least. So it's something to pay attention to, in addition to having your general business coverage. And lastly, M&A. I know a lot of folks out there have their eye, thinking strategically, not only for what they're trying to accomplish within the next 1 to 3 years, but maybe what their 5 to 10 year plan is with their organization. And sometimes M&A sort of percolates to the top of the list as a means of competing with larger companies, particularly where you're a small business and you're breaking your NAICS code and you're sort of sizing out, and you're thinking, well, if we purchase and buy another small business, we can add this capability to better compete. One of the things that folks need to be worried about is the cyber due diligence and quote, don't buying the breach. And so cybersecurity is here to stay. It's really a boardroom issue. There's a lot of again, regulatory changes happening with the government contracting sphere for defense contracting, but also as businesses, and business owners need to be wary of the fact that this is an issue that they may even be more targeted because they're doing business with the Department of Defense, but it's a general business issue to be thinking about. And we've seen attacks that are on small and mid-sized companies, and we've also seen the Target attack and the Capital One breach and all these large retailers. But just because you're a 30 or 50 or 100 person government contractor doesn't mean you're going to be immune from that. And so that really wraps up today's discussion. As I mentioned, at the beginning, we have the issues with operating agreements and teaming agreements and joint ventures. There's a lot of regulatory landscape that needs to be navigated carefully into the debriefing realm, and sort of using that tool proactively to not only build your relationship with agency personnel for potential future opportunities, but also to learn information so that you can better prepare for a different procurement in terms of proposal strength and also with respect to increasing your P-win rate. And then obviously with bid protests, that's a hot button issue we're dealing with, as the fourth quarter sort of plogs along here. We're almost to fiscal 21. We'll be seeing more and more awards. If you're the unsuccessful offeror, just be mindful of the deadlines that you're going to be working with. And again, if you're the awardee, you have the opportunity to intervene. And lastly, as I mentioned, the cybersecurity aspect is worth paying careful attention to, not just for the DFARS, but also for just implementing good cyber hygiene, because these ransomware schemes and malware schemes are not going away anytime soon. And so if we go to the last slide, obviously there's the disclaimer there, but here's my contact information if you have any questions. I believe Scott mentioned that there might be some questions. I'm not quite sure if there are, but I'm happy to answer if you have any. And so with that, I will turn it back over to Scott here. I appreciate everyone for listening. And
we sure appreciate it. You've covered such breadth and depth, and I, when it comes to these types of discussions, there's so many are unique to the individual business and the individual person and everything else. So I think typically what we find is that we're very thankful that you're willing to share your contact information, because there's those questions that do come up are so unique that people want to reserve that for a closer talk with an attorney or someone who may be able to answer their questions. And as has always been the case with you, we know that you're good for offering that contact information and outreach for those who may need help. So again, thank you for taking the time with us today, and we sure appreciate it, and we look forward to the next opportunity. I think you'll be sitting in on a panel with us in a week or so in more detail on CMMC, and
yes,
we look forward to continuing to engage with you and your expertise. It's great to see you again, and look forward to doing this again real soon.
Thank you for having me, and thank you for organizing the virtual VETS summit here. I know there's been a lot of learning that's been happening over the summer, so it's been an absolute pleasure to participate. So thanks.
Well, thank you, and as I said before, we appreciate your support of this series too, because you were first in on a supporter of this and seeing its merit. So you've really helped us all in that as well. So we'll see you next time. Thanks, Josh. Thanks everyone for being with us today.